The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon and welcome to the Court of Appeals. We have one case for oral argument on the docket this afternoon. And before we get to that, I'd like to introduce the panel. My name is John Tyson, and joining me today are Judges Allegra Collins and Judge April Wood. And I'd like to issue a special welcome for Judge Wood, as this is the first time that I've had the opportunity to sit with her since she joined the court last month. Like I said, we have one case on the docket for argument today. The case is State versus Helms, Court of Appeals number 2299 and 295. And if there are no further questions or items before we get started, we will hear from the appellant.
May it please the court.
Yes, Ms. Zimmer, good afternoon.
May it please the court. My name is Amanda Zimmer. I'm an assistant appellate defender, and I represent Bobby Helms. I'd like to reserve 5 minutes for rebuttal. There's one issue raised in this appeal: whether the trial court had jurisdiction over 2 counts of both first-degree sexual offense and indecent liberties with a child. Mr. Helms asked this court to impose a simple rule that would ensure both that the trial court has jurisdiction and that the indictments achieve their purpose. When the state seeks to indict a defendant for multiple offenses using identical language, it must either set those charges out as multiple counts in a single indictment or give each indictment its own file number.
So let me just jump in for a second. So if you're asking us to impose a simple rule, you're asking us to do something that's never been done before.
I would agree that it has never been done. I don't think there's a statute or a case that mandates it. I will say that I think it is what is commonly done and what is usually done when there are multiple offenses of this nature.
So it would be safe to say it might be the better practice, but there's nothing that mandates it in our current law.
It is safe to say it would be the better practice. I don't know that it is mandated. However, I would say that it is strongly suggested by our statutes. And if you look to North Carolina General Statute 15A-926A, it speaks to multiple offenses in a single indictment. And it says that 2 or more offenses may be joined in one pleading when the offenses are based on the same act or transaction or series of actions. And then it requires that each offense must be stated in a separate count as required by North Carolina General Statute 15A-924. And 924 simply requires that an indictment contain a separate count addressed to each offense charged. So even though this statute uses permissive language in 926 that say they may be joined in one pleading, it also says that it must be stated as multiple counts.
So do you read that as when offenses are joined and they're permissive, then they must be separate counts, correct?
Yeah. Yes.
So the joinder is permissive, and if they're not joined, then we're left with they need not be separate counts, correct?
No, I still think they need to separately set out offenses, which is where the confusion comes in with the file numbers here, because these appear to be single count indictments. They are single count indictments. The state contends that by submitting multiple substantially identical indictments, they are different counts, but that is not clear from these documents. I'm sure your honors have all reviewed multi-count indictments. And even if you look at the warrant in this case, there's 2 counts clearly set out on the face of the warrant. Then you get the indictment and you have a single count indictment. And there's one file number here. And that file number appears on what do appear to be copies of an indictment. It's only upon really looking at the handwritten portions of these 2 pieces of paper that you can tell there are slight differences.
But let me just jump in there, because you can see that they're not the same, because there are differences, in fact, that you can see with the naked eye, correct?
There are differences that you can see with the naked eye, but that's where what happened in State versus Hodge is sort of informative here. In that case, the procedure used was to submit multiple originals for the grand jury to sign. So even though there's some slight variations in these handwritten portions, we don't know that they were submitted as separate indictments. Even if there are visible differences in the handwritten portions now, they could be duplicate originals. And as it shows, this is what happened there, that there were two duplicate originals. So even those slight differences don't necessarily demonstrate that this was two indictments sent to the grand jury. And of course, because the grand jury proceedings are secret, we can't know exactly what the grand jury did in the grand jury room. We don't know if these were submitted to the grand jury as 2 counts, and they clearly considered whether or not there was sufficient evidence for 2 counts of first-degree offense or indecent liberties with a child. And
Just real quick, didn't the indictments follow the case numbers that were in the original warrant where there were 2 clearly identified and separate offenses alleged?
Yes, Your Honor, they did follow the file numbers. And if you compare the indictment to the warrants facially set out 2 charges. And because of how our sex offense statute is written, it's multiple acts could be charged either as multiple offenses or as 1 offense. We don't know. A prosecutor could have reviewed these allegations and decided to only pursue 1 charge of first-degree sexual offense. Just because the warrant clearly charged 2 counts doesn't demonstrate that this indictment was intended to show 2 counts of first-degree sex offense. And all this ties into what the purpose is of an indictment. And what the North Carolina Supreme Court has said the purpose is to identify clearly the crime being charged in order to give the defendant reasonable notice to defend against the charge and prepare for trial. And then additionally,
do each of these indictments on their own, are they valid on their own? If you're not attempting to say that we don't know that they're separate, when you take each one on its own, it does comply with statute, correct?
Yes, each one is a valid short form indictment.
Okay, and so and we have said that short form indictments and especially these are acceptable, correct?
Yes.
Okay, so the argument about in this case, wouldn't the remedy have been to ask for a bill of particulars if you're not sure if they're different?
No, Your Honor. I don't think that the remedy is to ask for a bill of particulars. Again, a bill of particulars cannot take the place of a valid indictment. The problem here isn't just notice. It's what the grand jury considered and whether or not the crimes were clearly identified. So was it clear from these indictments, or what the state contends were 2 indictments, that there were 2 charges here? Not the acts supporting the charges, but whether or not 2 charges were actually considered by the grand jury. And these indictments simply don't show that they were.
Do we consider the motion for joinder and the order allowing joinder that shows specifically 4 different offenses? Do we consider that in whether the defendant was able to tell that these were actually separate charges?
No, I don't think that we do consider that. The understanding of the parties cannot confer jurisdiction on the trial court. And if there's only 1 indictment for first-degree sex offense, no amount of agreement by the parties can grant the trial court jurisdiction over a second count that the grand jury never considered.
But if you're asking us to make a new rule, don't we want to look at perhaps what is understood by the current rule first before we go and make a new one?
Well, I don't think there is a current rule, Your Honor. To be honest, these statutes, 15A, 926, and 924, they don't mandate a procedure. And I think, as I believe it is custom, that this would normally be set out in a 2-count indictment. And that's what's seen most commonly. Or, as this court's dealt with before, there's multiple indictments dealing with a set period of time, and all of those indictments have their own file number. So it's very clear what the grand jury did in those cases. Here, I am asking you for a new rule, but I don't know that there is an old rule to change. I think there's custom and practice and a suggestion from the statutes at how this should be done, and what was done here just does not comply with custom or achieve the purposes of indictments or the statutes for multiple offenses. And I would say that the short form indictment here certainly complicates this issue. If there were multiple counts of larceny, it would be clear from the substance of the indictments that there were multiple counts. But because the short form indictment is authorized here, we don't have anything to hint at the fact that the grand jury in fact considered factual allegations to support 2 counts. So I think this is a very unique situation and a very limited situation. I don't know of another situation where the indictments can be substantially identical and charge multiple counts.
Let me ask a hypothetical. If we've got a case number that's just erroneous, right now we're essentially relying on the fact that we've got case numbers that are the same, right? 2 same case numbers with 2 charges in each. If we just have a plain old Scrivener's error in the case number, is that jurisdictional?
I don't think a Scrivener's error is jurisdictional when it comes later in the file, but this is the initial document. This is what starts a file.
So yeah, so I'm asking, is a Scrivener's error in the case number, is that jurisdictional such that we would have to throw out a charge if the case number was erroneous?
I think Your Honor's referring to the case cited by the state and Medina, what happened there, where the case
I
number
wasn't
got.
even referring to a case, I'm just giving you a
Okay.
hypothetical.
Oh,
But
well.
if there's a case on it, great.
There's a case that the state cites that talks about the file number. And I think what the file number is significant to here is the starting of a case. It's not just something down the line where there could be an error. We don't know, because this is one case number, that there were in fact 2 counts submitted to the court, to the grand jury. So I wouldn't say we couldn't know it's a Scrivener's error on the indictment itself. We could know there's an error later, like what happened in the case pointed out by the state, where the judgment had a different file number than the indictment. But on an indictment, I'm not sure how we could distinguish a Scrivener's error from a duplicate copy of something that was of the indictment itself. So I would say in that case, it is jurisdictional because we simply can't tell that it was as simple as a Scrivener's error. So without a clear indication of 2 file numbers, we don't know that these initiating documents were intended to set out 2 offenses.
Ms. Zimmer, let me ask you this. Do you agree that that 2 counts could be charged under 1 docket number for each?
Yes, Your Honor. If those 2 counts were clearly set out in separate counts as required by 15A 926.
So the fact they don't appear on the same page, why would that defeat them from being separate counts, the fact they're on separate pages?
I think here there's absolutely nothing to distinguish them. They don't incorporate each other. They don't refer to each other. The problem is here we just don't know if this is a duplicate or intended to be a separate offense and a separate count. I think sort of the confusion comes in referring to offenses and counts and indictments. When I think about what constitutes a count, I think about one document that sets out multiple offenses, count 1, count 2, and are usually pretty well labeled that way. As opposed to a
Do you agree that they're not exact duplicates, that there are material differences between the 2 documents?
Your Honor, I would not agree that there are material differences between the documents. The handwritten signed portions are different, but the substance of these indictments is exactly identical.
Let me ask you this then. Is it apparent from the face of the 2 documents that they're not the same document?
It is apparent when one scrutinizes the handwritten portions that they are not exact copies of each other.
And that's true for both counts on both indictments, correct?
That is true.
So if they're not exact duplicates, what's your basis for saying that there's error if you've admitted that you could allege 2 and 1 under 1 docket number, and you're not making any argument that these are identical?
Your Honor, the reason that this comes into play is that I agree there can be 2 counts alleged in a single file number on a single document when it is clear there are 2 counts. The problem here is that even with these slight differences in the handwritten portions, we don't know that they are truly intended to be separate counts. What if there had been 3 here? What if there had been 5? Would we have known that the grand jury really considered 5 indictments, or would they have simply signed 5 copies? We don't know, and that's the problem here. This creates an ambiguous situation that simply doesn't have to exist. As Your Honor said, there can be multiple counts in a single indictment. But what we have here is a single count indictment in the same file number, copied, and signed by a grand jury. So as in Hodges, where there were duplicate originals, there certainly could be duplicate originals here. We don't know. And that's the problem.
Wouldn't your argument be the same if you have the exact same verbiage that you've got on these 2 indictments in one single indictment as 2 counts? Couldn't you argue, how would we really know that the jury considered 2 counts when the verbiage in these 2 of both counts is the same? Is it simply because they exist on a single indictment?
Yes, Your Honor. I think the fact that they exist on a single indictment and that the grand jury has to show that sign that single document showing 2 clear counts shows that they had to have considered 2 clear counts. Unlike here, where we have 2 pieces of paper signed by the grand jury that appear exactly the same.
And
So
yet we don't have a rule that says that they have to be in one indictment, correct? You're asking for a new rule that says 2 counts must be in the same indictment.
I am asking for that rule, and I think that that rule is what is suggested by our statutes.
Suggested, but doesn't say, right?
Right. Well,
Okay.
It says may be joined and must be in separate counts. So the joinder of them is permissible in one file number if they're set out in separate counts. So here we have what the state contends is 2 separate counts set out in one file number, and they're not joined on one pleading. So I would say that there is not a rule, but the statute strongly suggests that if the state is going to indict multiple offenses in one file number, they need to be joined on one pleading. Does that answer Your Honor's question?
It does, but I have a quick follow-up. So in that, going back to that same statute about joinder, it says that the offenses may be joined for trial. You're not suggesting that when offenses are joined for trial that they must be in the same, that each offense must be stated as a separate count, correct? That second sentence doesn't modify that second part of the first sentence, correct?
Could you repeat your question? I'm not sure I understand.
Yeah, so when you've got, when we're looking at 926, and it says 2 or more offenses may be joined in one pleading, correct? Or for trial. So they may be joined in one pleading or for trial. And here we've got for trial, right? But you're not suggesting that each offense must be stated in a separate count simply because they were joined for trial, are you?
No.
Okay.
I think those are 2 separate issues.
Okay.
Because I think you can join multiple file numbers for trial as opposed to in one pleading.
Right. Thank you.
To Judge Collins' earlier question, I'm on record page 16 on the motion order for the joinder. It's clear prior to trial that your client had noticed there were 4 separate counts of 2 separate crimes. Is that correct?
That is correct, Your Honor.
When was an objection raised and preserved?
There was not an objection raised to the way that this indictment was returned. And I would contend that because it's jurisdictional, there did not need to be an objection at the trial court level.
Would you then agree that if we do not agree that it's not jurisdictional, that we have a preservation issue then? That your cases rises and falls based upon whether the Superior Court had jurisdiction. Is that correct?
Yes, this is a jurisdictional challenge.
There's no other basis there's no other basis other than that.
No, Your Honor. I don't think so. But I do think that even if this court were to require an objection, that this court could invoke Rule 2 here, because this is such a unique situation and at least address the merits of this issue. so that it doesn't occur again, because this does have the potential for problems. As I said, here we have 2 counts. What if there had been more? I just think the potential for confusion here and what the statutes require really should compel this court to address the merits of Mr. Helms' claim, even if this court ultimately believes this is non-jurisdictional. And just going back, the prosecutor here controls this method of indictment, and this is easily remedied. The warrants here, I would contend, show 2 counts on their face, and that's all that had to occur for the grand jury to find 2 counts, is for it to be set out on one document, or for there to be 2 file numbers. This is a simple rule. It would not impose a big burden on the state, and it would ensure that defendants are given notice and that the offenses are clearly identified.
Ms. Zimmer, let me jump in there real quick. What if it was on one document and the grand jury found a true bill of indictment on one count, but not on the other?
Well, I think in that case, Your Honor, they could not return a true bill of indictment, because both counts would have to be found in order for the jury to check the true bill box and assign that indictment. So I don't think under those circumstances we would have any valid indictment. I mean, certainly the state could then submit them as separate counts on separate indictments in separate files and see if they could get the grand jury to return a valid indictment. And we've been focused on the sex offense indictments, but the same problem here occurred for the indecent liberties. Again, the substantive language of the document was the same, and only upon really close inspection can you tell that there's a difference. On the indecent liberties charges, the judgment was arrested, and the trial court did that because the acts supporting the indecent liberties charges was the same as those for sexual offense, and the judge imposed a minimum sentence of 25 years each on the sex offenses, so he arrested judgment on the indecent liberties. Because that arrest of judgment does not have the effect of vacating the verdict, I'd ask that this court vacate one of the indecent liberties charges as well. Unless there's any more questions, I'll just quickly wrap up. Either setting out the charges as 2 counts on one indictment or in 2 indictments in different file numbers would have been sufficient to give the trial court jurisdiction over 2 charges, to clearly identify the number of charges, and to give the defendant notice of both the number of charges and the crimes charged. The method used here to indict Mr. Helms failed to do so. The trial court lacked jurisdiction to convict and sentence Mr. Helms for 2 counts of first-degree sex offense and indecent liberties with a child. For the reasons argued here and in the briefs, Mr. Helms requests that this court vacate one of the 2 judgments for each first-degree sexual offense and indecent liberties with a child, because he was properly indicted for only 1 count of each offense. And if it's okay with the panel, I'll just reserve any remaining time. Thank you.
Okay, Ms. Zimmer, you have about 8 minutes remaining for your rebuttal. At this time, we will hear from the state. Is it Ms. Euchre? Is that correct?
Yes, Your Honor.
Good afternoon and welcome to the court. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court. My name is Kristen Euchre. I'm an Assistant Attorney General with the North Carolina Department of Justice, and I represent the state in this matter. An indictment does not have to have a file number. It's absolutely no part of the accusation against the defendant. The file number is a mere clerical feature and plays no role in the jurisdictional sufficiency of the indictment. Defendant's argument here asks this court to find as a fact that only 1 count, not 2, was submitted to the Union County grand jury. But his argument must fail because this court is not a fact-finding court. And then, as he admitted in his argument, he's also asking for a brand new rule, a brand new legal rule, that all counts of an indictment must be under 1 caption or on 1 piece of paper, or else have different file numbers. but there is no authority that requires that particular format. Defendant shows no error in the indictments here, jurisdictional or otherwise. He argues that the challenge in this case doesn't involve the form of the indictment, but whether two valid indictments were actually returned. But of course, this is about the form of the indictment. His entire argument can be boiled down to that the two counts had to be on the same piece of paper or have a different file number. How is that anything but form?
Why wouldn't that be a good rule? Because when you look at these, you've got the exact same language. Because of the short form indictment, you've got no facts that help a defendant understand how many counts there are. Why wouldn't that be a good rule?
It's not that it wouldn't be a good rule, Your Honor, and it is often the common practice to follow such a rule, or not a rule, but to indict in that manner. However, best practices do not make jurisdictional requirements. There is, and beyond that, it's not a jurisdictional requirement, and it's not even any other requirement that has ever been stated by any of our courts or our General Assembly. This is simply a question of notice, and defendant here had actual notice. He admitted as much during his argument. It's clear from the record that he had actual notice. It's throughout the record. You've got the motion for joinder. You have all of the different mentions during the trial transcript of 4 charges or 2 charges of sexual statutory sex offense. It's clear that he had actual notice. So all of this speculation about maybe he didn't know is completely unfounded in the record. He raises no challenge to the charging language, and the charging language is what invokes the trial court's jurisdiction. A finding of error here, based on the failure to use a file number that has at least 1 digit different, would elevate form over function, and our existing law prohibits that. Defendant has made no attempt to rebut the presumption of regularity.
All right, I'm gonna jump in and ask, why should we even consider what happened after these indictments? Oftentimes when we look at the facial validity of an indictment, we don't look beyond the face of the indictment to determine whether it's valid. In fact, the defendant may have had every reason to understand what the state was trying to charge, but they just didn't do it right.
Right, Your Honor. We do only look to the face of the indictments, and by looking at the face of the indictments, we can see that there are, in fact, 2 different counts. There are 2 counts and there are 2 convictions. Matches up, just like Mandina says it has to do. The only reason that the state cites and brings up the other instances from the record is to show that defendant's speculation here is entirely baseless. He cannot simply bring in a fact from a separate case in a different county and create a jurisdictional flaw. There is absolutely nothing in this record to suggest that the duplicate originals procedure was followed in Union County, let alone in this case. He cannot simply look at the facts of a different case and say that might have happened here when everything in the record shows that to be false. Everything in the record shows these are different indictments with 2 different counts of each offense, and that the grand jury attested to its finding of probable cause for 2 different counts.
Let me ask, do we have a rule that actually allows 2 different counts in the same file number to be charged on 2 different indictments? I haven't found that rule. Does that exist?
Your Honor, I think that there's nothing addressing this particular situation, but I think that the issue comes in determining what is an indictment. What we have in this case, we have 2 different documents that have the same caption and the same file number. The mere fact that they're on 2 different pieces of paper does not make them 2 separate indictments. It is 2 counts of an indictment and they are separated on 2 pieces of paper.
You're gonna have to run that by me again. So you're saying that the 2 indictments that we have are not actually 2 indictments?
No, Your Honor, I'm saying that the 2 documents with the same file number are the way that the state wrote its 2 separate counts. So there's no requirement that defendant has cited or that I've come across that says anything about how many pages an indictment may have, anything like that. So we've got the caption, which says, you know, state versus Mr. Helms and county and all of that, that good stuff, which at the very, very top of that is the place where the file number is written. And we know that the caption is no part of the indictment. That's what our Supreme Court has said in Arnold. The caption is not a part of the indictment, although it is better to have it. It is not a part of the indictment, and any problem with it is not a jurisdictional issue. So what we have is the 2 counts are on 2 different pieces of paper, and they both have the caption.
So you're saying that the fact that the differences in these 2, we'll call them pieces of paper, since you're not arguing that they're different indictments, have different signatures and they have different check marks, but somehow it's the same indictment. The differences between these 2 papers don't make them 2 indictments. We disregard those and now it's 1 indictment.
Your Honor, I'm not sure I'm following. I think the ultimate point is that the file number is entirely irrelevant. We have 2 counts, whether they're under the same file number, whether they needed to be under different file numbers, whether they're on the same piece of paper or not. We have 2 counts, clearly 2 separate counts on 2 different pieces of paper, which have both been attested to by the grand jury, and they are jurisdictionally sufficient, as defendant has admitted. He has said that the short form language is sufficient. Our Supreme Court has held in multiple different cases that the short form indictment is sufficient to give notice as well as to protect against double jeopardy concerns. It is a sufficient indictment for jurisdictional purposes.
On page 7, the second indictment on the first degree statutory sex offense, there's a handwritten addition under the charging statute. Do you notice that? It does not appear in the first one. So it appears to be referencing to a separate statute between page 6 and page 7.
I don't see that. I'm looking at 6 and 7 and I don't, well.
Does yours not show 14-27-26 handwritten in?
No, Your Honor, I'm not seeing that. Mine just has the typewritten 14-27.4A1.
Okay. So do you agree, except for maybe the location of the file stamp, there is no difference between these 2?
I feel like, no, well, I guess I don't know what you mean by no difference. These are not
Are they identical? Or except for the position of the file stamp, are they identical?
No, Your Honor. They are not entirely identical. As defendant has conceded multiple times, all of the parts that are not printed on here by a computer, you can tell that they are different, either in different positioning or just having different characteristics.
Whether the same signature, same dates, the check marks are the same too, correct?
No, Your Honor. They're slightly different. The one on page 6 is not really fully in the box there. And then on page 7, the little X mark is the cross bit is fully inside of the square there. They look,
Okay, my point is, even though the same folks are checked and the same true bill is checked, correct?
yes, Your Honor.
Okay. Okay, I don't know when, I've got a handwritten edition on my record on page 7. It shows 1427-26 as the statute.
Yeah, I do not see that. And I don't know if any of the other, no, I
Okay,
don't know. I'm sorry.
we'll resolve that internally.
Okay.
Okay, so basically you're saying that the file number is entirely irrelevant, the fact that the clerk used the same file number for the 2 counts?
Yes, Your Honor. I think that this court's decision in Mandina makes it apparent that the file number is irrelevant, as well as the long line of cases from the Supreme Court saying that the jurisdictional sufficiency depends on the charging language, as well as saying that the caption is no part of the indictment.
Well, now that we've got short form indictments that do not have the allegations set out and detailed, how would a reasonable person know that they were being indicted under 4 separate crimes based upon what the state's presented?
Because he has received 4 different.
And the fact that they appear to be, I mean, to a layman, wouldn't they appear to be the same? Duplicates, maybe? Maybe think he was getting multiple copies of the same thing?
I don't know what a person would think. I just know that what is required for jurisdictional sufficiency is the proper allegation of the offense and the proper number of them, which is what we have. What the defendant would have understood, and for that matter, what the prosecutor would have understood is entirely irrelevant. If the prosecutor didn't even realize she was submitting 2 different indictments, that would be entirely irrelevant to the trial court's jurisdiction on that. That might raise an issue at some other point. If there really wasn't sufficient evidence, that would obviously be an issue. But the trial court's jurisdiction is dependent on the grand jury's finding a probable cause for a certain number of counts, which in this case, it did that. It found probable cause for 2 counts of each type of offense.
Thank you.
Thank you.
How many true bills were returned? How many documents indicating that true bills of indictments were returned?
4, Your Honor.
Okay. And do they each list the file numbers?
I'm not sure entirely. They each have a file number on them.
Okay.
Ms. Euchre, I have a question. On the notice of return of the bill of indictment, how many notice of returns of a bill indictment went out? With 2 or 4?
Your Honor, there's only 1 in the record, and the record is all that this court is really able to know. And it appears that there's 1, and the notice contemplates that there might be multiple true bills attached to it. So I don't know.
I'm showing 2 notices, one on page 10 and one on page 12 of the record.
Right. I asked about that and you said there were 4, but it appears that there are 2.
So what you're saying is that the indictments would have been attached?
I'm saying, I'm getting a little concerned now, Judge Collins, that I might have misunderstood your question before.
It might have been phrased very poorly, so it's
No.
probably my fault.
No, what I was trying to say was that there were 4 true bills returned. However many notices there were, it appears that there are 2 in this file, in this record, sorry, that there are 2 notices. And it looks like.
And is the fact that you said in this record, are you indicating that there are 2 others that are not in this record?
I have no idea, Your Honor. All I know is what's in the record.
And it was, but you get the opportunity to supplement, correct? If not everything's in there that you need to make your case, correct?
Sure, yes.
Okay.
And the two notices of return, I'm looking at them now, there's one for each of the file numbers. That's why there's two.
Is the notice of the return jurisdictional?
No, Your Honor. No. Nothing.
Would it be a due process violation or lack of notice violation to not give notice of the return?
I'm potentially, I mean, except in this case, the defendant obviously had actual notice. I don't know that notice has to be achieved by mailing out that form, but the defendant does certainly need notice of the charges against him.
I understand you to say that you do not know if the indictments were attached to this notice or not. Is that correct?
All I can know is what it says there, which it says that they were. I have no idea I don't know that anyone other than defendant would know if they were, and I suppose the clerk who prepared it. The document though is here, and it should, as far as I'm concerned, it should speak for itself, as do the indictments that are in the record.
And is it apparent from this document that this notice can include more than one true bill? Because
Yes.
it's got the S after bills in parentheses.
That is correct. Yes, Your Honor. So on that note, we can only know, as the appellate court, the only thing that this court can know is what appears in the record. Defendant has not and cannot point to anything in the record that would indicate a possibility of this duplicate original scenario that he has speculated about. Similarly, this, I don't know, this theory that the prosecutor might have overruled the law enforcement officer's charging decision and ultimately only submitted one of the two sex offense charges to the grand jury is simply completely unfounded as well. There's nothing in the record to suggest anything other than that these are two separate counts. And I will grant that it could be true, of course, that the prosecutor could have made such a decision, but it is obviously not true here. You have the multiple different instances of the prosecutor stating that she had charged 4 counts, most clearly in her motion for joinder, which indicates 2 counts in both of these indictments. Defendant is simply asking this court to find facts, which is not the function of the appellate court. This court is bound by the facts that appear in the record, which are that there are 2 counts. They are not photocopies of each other. Therefore, they are 2 counts. Similarly, this court is bound by Supreme Court precedent stating that captions are no part of the indictment and that short form indictments are jurisdictionally sufficient, even granting that they do not give notice of the specific sex act that is at issue. Our Supreme Court has directly dealt with that question and said that that has no jurisdictional significance, that if defendant has an issue with the needing to know the particular sex acts that are forming the basis of the charges, then he can ask for a bill of particulars, which is the way that the legislature has obviously set up for this to work. They put the short form into use, and they did not require specifying the sex act. And they also provided that a defendant can ask for a bill of particulars.
I'm just going to jump in with one question. I just want to circle back. And then I want to understand your argument clearly. We have 2 documents in each file number. Is it your contention that those 2 documents are 2 indictments, or are those 2 documents 1 indictment?
Your Honor, I don't know that there is any real significance to that.
That's all right. I just want to know if they're
Yeah.
two 1 indictment, or are they 2 indictments?
I mean, I suppose we could call them 2 indictments because they have, each one individually has every feature of an indictment. It has the count, the crime alleged there in a jurisdictionally sufficient way. It has all the grand jury attestation information. It has the caption showing who the indictment is returned against and in what county. Sure, they're 2 indictments. There's no reason to not call them that.
2 indictments for each charge, or wait a minute, 4 indictments total, correct?
Yes.
Is
yes,
that what the state's saying?
Yes.
Are you also saying it's wholly irrelevant that the clerk, or they were filed under 2 different docket numbers as opposed to 4 docket numbers?
Yes, Your Honor.
So that has nothing to do with the validity of the indictments?
That is correct, Your Honor. There is absolutely no authority for the proposition that they must take some other form. There's nothing that even says there must be a file number at all. I can't imagine that an indictment would be jurisdictionally flawed for not having a file number at all.
So the state's position is they'd be valid 4 separate charges with no file number, or even if all 4 charges were under 1 file number. Is that the state's position?
Yes, Your Honor.
Okay.
The file number is simply irrelevant. It is a mere housekeeping tool. The fact that there are 4 counts that have been returned by the grand jury, and those counts are all alleged with sufficient language, is all that is required for jurisdiction. Other form requirements of indictments, for example, like the one at issue in Bryce, those are things that a defendant must raise to the trial court in order to be able to get relief on appeal for them. And in Bryce, there was actually a violation of an existing statute. And our Supreme Court said that that was not a jurisdictional issue, that it was a form issue that needed to be raised with the trial court, even though the statute and the form was something that was based in an important purpose and had an important purpose. It still did not relieve the defendant of his burden to challenge that form because the indictment was jurisdictionally sufficient.
Okay, anything else from the state? Do you have any other arguments? I think we understand this argument. I don't want to, cut your time short. You have more time, but if I don't see that we need to repeat the same argument over and over. Do you have anything else you'd like to add?
Just very briefly, Your Honor, I just want to highlight that sufficient notice in and of itself is not a jurisdictional requirement. It flows from the sufficiency of the charging language, but it is not an end of itself as far as it is not a requirement of itself for jurisdiction. Sturtevant mentions that adequate notice of the nature of a criminal accusation is a necessary corollary of the jurisdictional requirement of an indictment, but the right to notice merely affords the defendant the right to be charged by a lucid prosecutive statement, which factually particularizes the essential elements of the offense. So it's clear they are related. Bryce mentions as well that they are related concepts, but merely some sort of issue with the notice is not a jurisdictional defect. And I guess I just wanted to highlight as well, in the event that this court does want to create some sort of new rule, that rule application of that rule is waived because defendant did not make this argument below. So he's stopped. The matter is res judicata as far as he failed to raise it in his first appeal. He didn't raise it in the trial court. So he's barred in two different ways. And those are bars that cannot be overcome by Rule 2. Rule 2 allows this court to relax the rules of appellate procedure, and res judicata is not a rule of appellate procedure. And moreover, there would be no manifest injustice here that would even warrant invoking Rule 2, because as we can see from the record, defendant and his attorney and the trial court and the prosecutor, all of them were on actual notice that there were in fact 4 counts here. So I would just emphasize that defendant has admitted that this would be a brand new rule and that these are 2 different counts on 2 different indictments, that they are not in fact identical. And yet he asked this court to import the fact from Hodge to make some sort of ambiguity in this case, which is simply not something that this court can do. Find a new fact that there's only 1 indictment here when the record clearly has 2. And I guess I will close at that. The state simply asks this court to affirm the judgments, and thank you.
Okay, does the panel have any further questions of the state? Okay, thank you very much for the argument. We will now return to Ms. Zimmer for rebuttal.
May it please the court. I have just a few points in response. First, it's not just the language of the indictment, of the substance of the indictment, that gives the court jurisdiction. It is the existence of an indictment. It is the role of the grand jury to find probable cause. It is the role of the grand jury to stand between the citizen and the state. And when the state wants to charge multiple offenses, it should make clear that the grand jury has found probable cause for multiple offenses. The state repeatedly.
Let me ask you this. Had there been 4 separate docket numbers on the file, would the defendant have any question about the 4 separate indictments or not?
No, Your Honor. I would say at that point, if there are 4 separate file numbers, there are 4 facially different indictments that show that the grand jury considered 4 counts. What we have here.
But you've already admitted they're not identical.
I have admitted that they are not identical in the handwritten portions of those indictments. And I will contend that duplicate originals are often used. So I don't think that those handwritten portions change my argument. In essence, my argument remains that there is a single indictment here, even if 2 were signed by the grand jury.
Well, and is the sole basis of that the 4 charges are under 2 docket numbers instead of 4? And how is the docket number jurisdictional?
No, Your Honor, it's not solely based on the docket number. And this is what I was saying with the problem with the short form indictment under this circumstance, is that it's not just the caption that's identical. It is the substance of these indictments that is identical. So on the face of these documents, you can't tell them apart in any way.
Ms. Zimmer, would your argument be any different if the indictments themselves set forth count 1, count 2, like the warrants do, and the verdict sheet? Is that
Absolutely, absolutely, Your Honor.
Then there would be some sort of facial difference if there was just the number 1 and the number 2 on the documents?
Yes, even if these had been 2 separate pieces of paper, if one said count 1 and one said count 2, then again, it would be clear from this record that the grand jury considered 2 separate charges. And that's really what we're talking about here. Count 1, count 2 is just a way of saying how many offenses that the grand jury considered. And that's what's important. Whether or not there's a grand jury finding on 4 substantive counts, and nothing in these documents shows that that's what was submitted to them or that that's what they returned. So
Can you walk me through, so we've got this notice of return of bill and indictment, we've got two of them, right? We've got one in each
Yes.
file number. It seems to me that the notice of return is actually internally inconsistent in that the first sentence allows for more than one indictment, right? But the rest of the document speaks to only one indictment, correct?
that is correct, Your Honor. I will say, as just a representation to this court, that like I have seen a notice of return of indictment, one document for multiple file numbers. I have seen multiple indictments returned that way with the notice. And I will represent to the court that I reviewed the court file and these two notices were the only two notices of return of indictment in it. And that it is not clear from the file I received what was attached to them when they were sent to the defendant's attorney. I also think it's interesting here that this was served on the defendant through his attorney. So if there were two copies, someone could have gotten this and easily thought, oh, this is a single count indictment. Here's a copy for me and here's a copy for the defendant. So what we have here is really what a reasonable person would understand is important, because they have to defend against this. It can't create jurisdiction in the court, but what a reasonable juror might have understood, what a reasonable person looking at these documents might see is that there's a single count indictment for a sex offense and a single count indictment for indecent liberties and copies. Because no one should have to bust out a magnifying glass to determine that there's a difference here, to see that two counts were considered by the grand jury. And that's really the problem with what happened here. The state's argument that the file number is completely irrelevant is interesting, because if the exact same indictment was submitted 5 times and the file number is not different, how does the grand jury know that these are actually different? How is a record created that makes it clear to a defendant what the grand jury considered? And asking for a bill of particulars is never going to answer that question, because a bill of particulars cannot fix a defect in an indictment. And the reason for that is because the grand jury has nothing to do with a bill of particulars. So here, the problem is that this is just not clear what the grand jury did. And the way that the short form indictment statute allows the state to indict these offenses doesn't provide any substantive difference in the count.
I want to ask a quick question. So we can see that the bill that was returned, right, has differences in the handwritten portions, correct?
Correct.
Is there anything about the two bills, the two indictments in each case file that would have been different going to the grand jury? Is there any handwriting that they would have seen that was already on it that would have been different? Is there any stamp? Is there anything? The
only handwritten portion before the grand jury signs it, to my knowledge, would be the prosecutor's signature. And so that portion could be different. Again, just a handwritten portion. That the prosecutor's signature is the only portion that I believe is filled out before it's going to the grand jury. I don't know about the X for the witness. I don't know if the grand jury fills that out or if the prosecutor does.
Thank you.
Just to reiterate, this is not a challenge to the use of a short form indictment. It is a challenge very much to whether or not there are two indictments here, or if there are one. The state's confusion over whether this is 2 counts or 2 indictments or 2 counts of 1 indictment shows the problem here. We don't know what to call these because it appears to be 1 indictment. Doesn't appear to be 1 indictment with 2 counts. It simply appears to be 1 indictment. The rule here is jurisdictional. It is needed to ensure jurisdiction. It is not, I don't believe, it is a new rule, but there is no old rule. There's custom and there's requirements for notice. And this method of indicting the defendant simply did not provide jurisdiction to the trial court because it's not clear what the grand jury did. Accordingly, Mr. Helms would ask that this court vacate 1 of his convictions for first-degree sex offense and 1 for indecent liberties with a child. Thank you.
Thank you. Thank you, Ms. Zimmer. Any further questions of the defendant from the panel? Okay, hearing none, we'd like to thank counsel for their arguments today, and We appreciate the briefs and the arguments, and we will now consider the case submitted. And if there's nothing further, I would ask the clerk to please adjourn.
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you, everyone.
Thank you. We'll talk to you in a minute.
Council.
Thank you.
Thank you.
Thank you.